Welcome to our webinar today, Commercial Tobacco Control and Food Security in 2021, Regulatory Opportunities. I'll move us to the next slide. Thank you. All right, in case you haven't worked with us before, we're attorneys at the Public Health Law Center. We're based out of the Mitchell-Hamlin School of Law in St. Paul, Minnesota, which we want to acknowledge is the historic lands of the Dakota people. This region was known as Bedote, and it was the center of all things for the Dakota people. I will also acknowledge that my home, where I'm speaking from to you now, is located just a mile or so from the site of the Dakota village of Kaposia, which was relocated here after the Treaty of 1837 forced the Dakota people from their ancestral lands. They were then removed from this area again in 1851 by another treaty with the United States. I appreciate the ongoing stewardship, spiritual connections, and lifeways developed in these homelands upon which I occupy. I also acknowledge and thank the diverse Indigenous peoples whose footsteps have marked this territory and have joined into community here in this region. All right, next slide, please. At the Public Health Law Center, all of our work is grounded in and centered on advancing equity. That means we focus on public health goals that support everyone in our communities by recognizing the systemic disadvantages and unique obstacles groups and individuals may face in living healthy lives. We work to encourage communities to advance policies that will provide greater protection to those who have experienced the greatest disparities. And if you haven't worked with us, we would love to help you. We provide a service that we call legal technical assistance, which takes a variety of forms. You'll find hundreds of publications on our website. We host trainings and webinars like this one. The bulk of what we do is individualized. So we're funded to answer the legal questions that are often inherent in policy work. The only things we don't do is lobbying. So we don't engage directly with certain policymakers, and we don't do direct representation. So we don't go to court on anyone's behalf, but we're happy to help in any way that we can if you're working to advance public health policy. I'm really excited about today's webinar. We'll be discussing some of the latest developments in the executive branch that have happened since the new administration took power. You'll hear from 3 of our staff attorneys. Rebecca will be discussing an 11th hour Trump administration rule and some more global updates. And then you'll hear from Kyra and Amanda to discuss what might be on the agenda for the next year and years in both commercial tobacco control and food security. And at the end, we hope to provide some time to answer your questions. And with that, I will turn it over to Rebecca.
Thanks, Desmond. Now I'm going to talk a little bit about the Department of Health and Human Services sunset rule, which unfortunately is not quite as lovely as a sunset picture here. Next slide. Sunset is shorthand for securing updated and necessary statutory evaluations timely. Now that's a little bit of a mouthful, so I'm just going to be referring to it as sunset. The finalized rule came out of the Trump administration and out of the Department of Health and Human Services just in the final days, finalized the day before Biden's inauguration on January 20th. It's really anticipated to have significant impact on the department's operations, and the rule itself establishes a plan for retrospective regulatory review by the department and all of its sub-agencies, including the FDA. And there are very limited exceptions to this rule, and I'm going to talk about the key provisions next. HHS justifies the need for this rule to incentivize its own compliance with the Regulatory Flexibility Act. Again, another mouthful, which I'm going to describe as RFA. So the RFA requires periodic review of rules that have a significant economic impact on a substantial number of small entities. So the RFA requires agencies to create a plan to fulfill their periodic review requirements of these rules. However, the RFA does not grant agencies authority to broadly institute expiration dates for all the regulations to achieve this purpose. Regardless, the sunset provisions provide that many regulations by HHS or sub-agencies such as the FDA will automatically expire unless the agency performs specific retrospective, so like in the past, review activities outlined in the rule. So these are rules that have already passed, but they need to go back and review them under RFA. So with this approach, it's possible that many affected regulations would not require review under the RFA, but the sunset rule goes ahead and it will add a whole layer of formal processes that are required for all of these regulations to undergo in order to prevent expiration. So how does this sunset provision operate? So sunset means to expire. and that's what we're talking about here. The sunset date for each regulation will be the latest of 10 years after the regulation's promulgation, 10 years after the regulation was last assessed, and if required, reviewed, or 5 years after the sunset rule first became effective. So what does that mean? That means that any regulation that is currently 10 years since promulgation and hasn't been reviewed in the last 10 years would expire within 5 years if it is not assessed and reviewed by HHS or a sub-agency. So we're looking at 2026 if it goes into effect in 2021. And according to HHS, several thousands of regulations would need to undergo this process within the next 5 years in order to prevent expiration under the rule. And the rule is currently set to go into effect in March 22nd. So here I put together a little timeline so you can kind of see how this rule reached the public and where we are right now. So the timeline for public notice and comment for this rule was significantly abbreviated. As you can see here, the department's interest in a new expiration incentivized review scheme was introduced to the public in early November. So that was just a little over 3 months ago, via a proposed rule in the Federal Register, which started off a comment period. HHS split that comment period, requiring comments on most of the rule within only 30 days, and then allowing 60 days for comments on certain other parts. Many commenters on the rule requested additional time because really being able to provide a meaningful comment on this rule requires more than 30 to 60 days. It's a massive rule that's imposing novel sunset provisions, and the public needs time to review those individual regulations in order to provide a meaningful comment to the agency. HHS did hold a public hearing on the rule. However, notably, every commenter who attended that hearing expressed concerns about the rule, opposed the rule, or requested an extension to the public comment period in order to provide meaningful comment. These sentiments were shared across public interest organizations and industry representatives, which is pretty notable for a rule of this magnitude. And really, the fact that this major rule was rushed at a time of administrative transition and shift in regulatory priorities, I think further underscores that the agency was motivated to get this rule finalized, regardless of the substance of public comment or the chorus of requests for an extended public comment period. In fact, the department announced the final rule only 4 days after the public comment closed. And I think, again, this calls into question whether those comments were given due consideration, particularly when many of those comments raised significant issues and concerns with the proposed rule, which I'm going to talk about next. So the sunset rule raises several procedural issues under the Administrative Procedure Act, or many abbreviate it APA. And this was raised by many commenters on the rule. The APA itself outlines specific requirements for agency procedures, including public notice and comment, and it requires agencies to provide a satisfactory explanation of their actions under APA's related case law, and requires agencies to consider all important aspects of the problems that they seek to address through their rulemaking. For starters, the rule itself would likely be found arbitrary and capricious for lack of agency review of the thousands of regulations amended by this rule. An agency must consider changes it intends to make and provide a reasoned explanation with any deviation from past practices. So in this case, the department did not individually review all of the regulations that would be affected by the sunset provisions or provide any explanations for the change in the policies that would result if any of these individual regulations were to expire under their sunset provision. So further, coming back to the rule timeline we discussed, the comment periods were likely too short to allow for meaningful opportunity to comment, which is also an APA requirement. And we also see procedural issues that are just compounded by the sunset regime itself. So the automatic expiration of regulations without opportunity to comment, that would violate APA notice and comment rulemaking procedure. And further, expiration of these rules just automatically in the absence of agency action, that would also be arbitrary and capricious because the agency has not provided any reasoned explanation In fact, they have made no decision at all. It's in the absence of making a decision or review. So that's another consideration, and why we are concerned about this rule and its impact. Next slide. So to recap that litany of potential issues with this rule, the sunset rule likely lacks statutory authority under the RFA, so the Regulatory Flexibility Act, due to its expansive nature. The sunset rule violated APA procedural requirements in its own promulgation, both due to denial of meaningful opportunity to comment due to the short comment period, and the department's lack of review of the regulations that will be amended with a sunset provision. And once effective, the operation of a sunset provision would automatically violate APA procedure if any regulation were to expire without any consideration by the agency. Further, there are just concerns as to whether this review process will affect the department's ability to function and address pressing issues of public health. So based on all of these concerns, the rule clearly needs to go. And there are several ways that that could happen. So the rule is ripe for withdrawal by the department, which would reopen a notice and comment period under APA. If confirmed for the role of HHS Secretary, Xavier Becerra will likely take this approach. As the Attorney General for the state of California, Becerra, along with other states' attorneys generals, filed a comment opposing this rule, challenging its legality under the APA and raising concerns about its anticipated negative impacts on public health, the agency's work, and uncertainty for regulated entities. So it is unlikely, if confirmed, Becerra would continue with this rule if he has already argued that there is questionable legality under the APA. Another option would be a rulemaking petition that could request the department to withdraw the rule. And then if granted, the department would initiate the same public notice and comment process for withdrawal. Congress could also decide to disapprove of the rule under the Congressional Review Act, the CRA, and we'll discuss that more in a moment. And finally, there is also the possibility of litigation, where a court could vacate the rule for violation of APA or for exceeding the department's authority under the Regulatory Flexibility Act. So that was just a brief overview of the rule, and hope we don't have to talk about it again, but we'll see. Now looking forward, we want to talk a little bit about what's on the horizon for the regulatory agenda as we head into 2021. So getting back to the Congressional Review Act, and it has quite a possibility that it could affect the regulatory agenda. We haven't seen that quite yet going into the administration, but it has proven to be useful in the past, particularly at the beginning of the Trump administration, in terms of undoing some of these last-minute rules. So under the Congressional Review Act, recently finalized rules are required to be transmitted to Congress, where Congress has the ability to review and disapprove significant regulatory action within a specific time frame. The act requires that a joint resolution disapproving of the action be passed by the House and Senate and signed by the president. In the event of a presidential veto, Congress could override with a 2/3 vote in the House and Senate. However, one key aspect of disapproval under this act is that the agency may not issue a substantially similar rule in the future unless specifically authorized by law enacted after the date of congressional disapproval. So the Congressional Review Act is an important tool to be aware of, both as it relates to sunset, as we just discussed, but also as it may relate to other recently finalized rules. But however, there is that caveat that if disapproved, the agency would not be able to pass or enact another substantially similar rule without further authorization. So next, I want to talk a little bit about recent executive action under the new administration. On President Biden's first day in office, he released 2 memos pertaining to federal regulatory priorities, as well as an executive order revoking other executive orders. And all of these have direct application to the sunset rule as well. So the first memo I want to discuss directs agencies to initiate a regulatory freeze. This is a common executive order. The regulatory freeze memo requests that agencies postpone upcoming rule effective dates for 60 days or longer if needed. And they review any issues of fact, law, or policy by these postponed rules, potentially open a comment period on these postponed rules, and consider any pending petitions for reconsideration. The memo further states that any actions taken prior to the beginning of the administration that would frustrate the purpose of this memo would be subject to further review and action. So, while the sunset rule wouldn't require postponement since its effective date is technically already 60 days after the memo, March 22nd, the memo was released January 20th, HHS should still undertake review of the rule in keeping with the purpose of the regulatory freeze. Another memo addressed to the heads of departments and agencies directs the Office of Management and Budget, or OMB, to work with the executive branch departments and agencies to create recommendations for modernizing regulatory review. So the memo advises that these recommendations should be informed by public engagement and consider how the regulatory review process can really promote public health, social welfare, racial justice, and equity, and then a number of other considerations. So based on this, executive branch-wide visioning for regulatory review, HHS should withdraw the sunset rule to prevent undermining the executive's intent in modernizing regulatory review around these specific stated priorities. The sunset rule was reviewed prior to this directive, and OMB likely did not prioritize these considerations in doing so. And if not, it should still be reviewed. And finally, I just want to briefly mention Executive Order 13992, which revokes executive orders from the prior administration pertaining to deregulatory practices. So one of these executive orders is 13771, known as the one out, two in. Wait, I think I said the opposite. So anyway, for every rule to go out, which is kind of a more formulaic method rather than holistically considering what is needed in the regulatory state. So the sunset rule is designated as a deregulatory rule under that executive order, and that executive order was revoked by 13992. So for this reason, HHS has even further reason to withdraw the sunset rule, simply because we don't know whether or not it was intended to implement 13771, and if it was, then it certainly should be withdrawn per the 13992. And finally, turning to the executive outlook, we want to look at some of the executive priorities. The Biden-Harris administration has announced several key priorities that include controlling the COVID-19 pandemic, of course, providing economic relief, tackling climate change, and advancing racial equity and civil rights. So the immediacy of these key priorities and intersection with multiple health concerns is really encouraging, and we're closely watching to see how these administrative goals tie into existing public health efforts, and that's what we're going to talk about next. And finally, moving into the new administration, we do want to highlight that there are some key transitions in agency leadership. These include Acting Secretary Norris Cochran at the helm of HHS, replacing Alex Azar. Cochran was previously the HHS Deputy Assistant Secretary of Budget. Xavier Becerra has been nominated for HHS Secretary and is awaiting confirmation by the Senate, and his hearings began today. Becerra most recently served as the Attorney General for the state of California, and prior to that appointment, Becerra served in Congress for over 20 years. At the FDA, our current acting commissioner is Janet Woodcock. Woodcock has a long tenure working at FDA and most recently served as the director of the FDA's Center for Drug Evaluation and Research. The administration has yet to nominate a permanent commissioner, and the acting commissioner, as well as others, are currently under consideration. Finally, likely replacing Sonny Perdue at the head of the USDA is Tom Vilsack, who has been nominated for USDA Secretary. The Senate is expected to vote on his confirmation today, and Vilsack served in the USDA Secretary position for 8 years under Obama administration and previously served as the governor of Iowa. Now we're going to turn to those regulatory opportunities in commercial tobacco control and food security. Kyra?
Great, thank you so much, Rebecca. As Rebecca said, my name is Kyra Hill. I am a staff attorney on the commercial tobacco team at the Public Health Law Center. So I'm here to briefly talk about some updates on the federal regulatory horizon in the commercial tobacco space, and then identify some of the opportunities we see for regulation in the coming year. Next slide, please. So in order to provide a little bit of context, I'm going to back up to 2020 and talk about the T21 regulations, and then we're going to talk a bit about the regulations that were initially slated to come out in late January of this year, 2021. Next slide, please. So first, T21. It seems like a very long time ago now, but you may remember that at the end of 2019, Congress amended the Tobacco Control Act to reflect a new minimum legal sales age of 21. So although Congress did effect a change in law immediately, it also required the FDA to issue regulations implementing that change, which included updating a few other areas of the act that referenced the minimum legal sales age. Next slide. What's the status of that rule? Well, we know it went to the Office of Management and Budget, or OMB, which Rebecca just referenced, on September 2nd of 2020. And it was sitting at OMB for 3.5 months before it was finally withdrawn under the regulatory freeze pending review memorandum issued on January 20th by President Biden that Rebecca also just discussed a little bit ago. So we're still waiting on the rule to be issued by the FDA. We don't know when that's going to happen. Keep in mind that the minimum legal sales age is still 21 everywhere, so it doesn't have any bearing on that. And as far as we know, FDA and states are updating their enforcement contracts to reflect the new age, even absent regulations from FDA. But that is hopefully coming soon on the FDA regulatory horizon. Next slide, please. The other set of regulations that we thought were on the horizon had to do with the pre-market review tobacco application, or PMTA, process that's required of new tobacco products under the Tobacco Control Act. So pre-market review is one of FDA's most powerful regulatory tools, and it really makes the agency the gatekeeper of the tobacco product marketplace. So products that were not on the market before February of 2007 or have been modified must receive marketing orders from the FDA in order to be sold. Products that have what are called predicate products can apply to go through a process called substantial equivalence, or SE, or may apply for an exemption from SE. All other new products have to go through the PMTA process. So 2 rules containing requirements applicable to both the PMTA process and the SE process were published in September of 2019, respectively. And those rules laid out the requirements for applicants for each of these processes. So next slide, please. What happened to these rules? Well, as you may have guessed, because of their timing, they were also pulled under the regulatory freeze pending review memorandum issued by the Biden administration on Inauguration Day. So, of course, there was significant justification for that memorandum with concerns about a bunch of 11th hour regulations from the former administration. But given that there are to date no regulations spelling out the pre-market review process for products that are currently undergoing pre-market review, I'm hoping that some iteration of those rules will make their way back to the Federal Register sooner rather than later. Next slide, please. So speaking of pre-market review, let's talk a little bit about how that process is progressing. Last week, the FDA announced that as of mid-January, it had received applications for 4.8 million products from 230 companies. Of those, it has, quote, accepted 58,000 of them. Acceptance is just the first phase of the review process, though. It doesn't mean that the products have actually received marketing orders. So in short, the FDA has really gotten to the first stage in only 1.2% of the applications it's received of that 4.8 million. And given that we're now coming up on 6 months from September 9th, which was the submission deadline, this process is progressing much more slowly than we had hoped. As of September 9th of this year, of 2021, products that have not received affirmative marketing orders from the FDA will have to come off the market. So the FDA will have had a year to review applications. And in fact, a lawsuit by public health groups against the FDA in the District of Maryland established that time frame with input from the FDA. So it was well aware of that time frame. It's unclear at this point what will happen on September 9th of this year, of 2021. The upshot really is that reviewing the marketing applications for the millions of products should be top of mind for folks at the FDA Center for Tobacco Products in the coming months. Next slide, please. So what else, if anything, is on the FDA's radar when it comes to tobacco products? The only thing that has been published in the Federal Register this year so far was revised guidance for industry relating to submitting plans for cigarette advertisements and packages. As some of you may remember, the updated graphic warning label rule for cigarette advertisements and packages was issued on March 18th of last year. But then both RJ Reynolds and Philip Morris sued along with other industry plaintiffs in 2 different federal courts. The federal court in the Eastern District of Texas postponed the graphic warning label's implementation date until January 14th of next year, 2022. So this guidance relates to that postponed timeframe and submission requirements. Next slide, please. So I also want to talk a little bit about some of the outstanding requirements that the Tobacco Control Act requires the FDA to do and that FDA has not yet done. So first, the Tobacco Control Act requires FDA to issue rules relating to the sale, distribution, and marketing of products occurring in non-face-to-face or remote transactions. An advance notice of proposed rulemaking seeking information was issued in September of 2011, and which related to that requirement, but nothing has occurred on this front since then. So some of you may be aware that recent changes to the Federal PACT Act impacted retailers' responsibilities with respect to sales of e-cigarettes online. But the FDA has a really broad authority and a mandate to regulate non-face-to-face sales, including their marketing, which is not at all impacted by the PACT Act. So, and it has yet to do so. So that is something that is still outstanding and required by the Tobacco Control Act. Next slide, please. And then lastly, the Tobacco Control Act also requires the FDA to issue regulations that impose requirements for tracking and tracing products and product sales. To date, we've seen no proposed rule on this issue, although it's something that the international community has been moving forward with in recent years. So hopefully there's some lessons learned lessons to be learned from that experience, but we still have yet to see any effort to move forward with implementation of that provision, which could help with concerns related to things like illicit trade. So that was a very quick run through of what's on the horizon for the FDA this year. If you have any questions about this, I'm happy to answer them at the end of the webinar or follow up afterwards. So with that, I will turn it over to Amanda. Thanks.
Great. Thanks, Kyra. So again, I'm Amanda Karls. Like my other colleagues on this webinar, I'm also a staff attorney at the Public Health Law Center. And I'm really excited to have the opportunity to talk to you today about an emerging area of our federal agency Watchwork. Specifically, recently at the Public Health Law Center, we've been expanding our regulatory watchwork outside of commercial tobacco control and related FDA areas to also include review of regulatory activity and opportunities in the area of food security. And these are, we're specifically focusing on especially opportunities to improve food regulation under the FDA, as well as food programs under the purview of the USDA. Next slide. I'm sorry, back. Nope, you're right. That's the slide. Good job. Our specific focus is on food security. And by that, we're meaning not just access to food, but access to affordable, sufficient, safe, nutritious, culturally appropriate food. And this sort of framing is really consistent with the Public Health Law Center's commitment to push for changes to uproot and dismantle systemic racism and other barriers to health equity. And in this work, we're joining other allies that are also looking at this space. So we really hope to use our skills as attorneys to understand where there are gaps in regulatory law and administrative processes that could be improved. And really importantly, to elevate the voices of others, which is something that I personally believe is especially needed in order to align law with justice. And so in doing this work so far, we have relied on generous support from Blue Cross Blue Shield of Minnesota to begin building out this area of our federal regulatory work, but we are still exploring funding options to be able to grow the program, including especially to provide technical assistance. So at this point, our project remains really in the emergent stage, but I'm excited to share with you a bit of a preview of just some of the types of issues that we've been looking at and that we intend to look at, as well as a glimpse of some of the ways that we've actually already been able to engage so far on issues that are going to be important as we move into the rest of 2021 and beyond. Next slide, thank you. So for today, I'm going to be focusing on some of what we're expecting and watching in the regulatory space in terms of rulemaking and potential rulemaking and some related agency flexibilities. And this screenshot here just sort of gives you a glimpse of the scope of what we're currently looking at in that regard. But I also want to note that we're also tracking litigation that affects these key regulatory areas. I think this is important and really a unique way that we can participate in this space because amicus briefs are sort of an area where advocates and others can have an opportunity to influence judicial holdings that affect whether or not, for example, an administrative rule is invalidated or upheld. And I think that going forward, this is really an area that we as attorneys and also policy analysts at Public Health Law Center would really be able to, would really like to be able to be a resource for in the future. Next slide. So just kind of giving you a sense of what we've been looking at and what we're kind of anticipating coming or going forward. Starting with FDA, one thing that we've been watching and really working on is better regulation for so-called toddler milks and similar beverages. So back just last year in 2020, Public Health Law Center joined several other public health and nutrition groups in filing a citizen petition calling for better regulation and enforcement around these beverages, which are promoted for consumption by small children. So these are different than sort of infant formulas. We're talking about formulas that are marketed for children over 12 months old, typically. And the problem, I guess, in a nutshell, is that current labeling and marketing of these sort of sometimes called transition formulas or toddler milks can really create consumer confusion. Confusion that these are products that are either the same or similar to the infant formulas. And also the impression that plain unsweetened milk and other whole foods are somehow nutritionally inadequate to meet the needs of otherwise healthy children. And, this is especially problematic because these products are not recommended by public health experts or nutrition experts, and they often contain added sugars. Another big problem with these products is that they're often, as compared to cow's milk, expensive. And so they can cause potential economic harm for families, including especially families with lower incomes, which are disproportionately Black, Indigenous, and people of color. Another opportunity that we're sort of seeing some movement around, though there isn't a pending citizen petition around this one, is the idea that there could be better menu labeling around added sugars. So right now for, in the restaurant space, that is. So right now for restaurants that have, that are chain restaurants that have 20 or more locations, there are requirements for calorie disclosures on menu boards and printed menus, as well as the requirement that upon request, consumers can get additional information to find out about additional nutrition facts. But unlike, for example, you'll see here, I've got on the screen a nutrition facts label on a packaged product. There is information related to added sugars. That information is not currently being required to be disclosed under this 20 or more chain restaurant nutrition disclosure. And so this is an area where, as I mentioned, advocates are sort of looking to see the FDA make changes to provide consumers with additional information. And then just in terms of other things we're following, and again, all of this is sort of just a kind of a highlight and overview of some of the things that we're watching, but just to kind of give you a sample, I'm hitting on a few things. We are also noticing some activity at FDA related to non-traditional sugars and sugars that might be metabolized differently than traditional sugars, as well as a related citizen petition coming from the Sugar Association. And so as we see the FDA kind of thinking through what some of the issues might be around some of these alternative sugars, we might expect to see some additional labeling requirements happening in this particular area. And this is, of course, something that health advocates and others are going to want to watch and make sure that they're participating in kind of any rulemaking or studies that are being done in this particular area to ensure that consumers really have the information that they need to make informed choices when they're evaluating a different products for purchase. And then also we're continuing to watch what might happen under the Biden administration regarding some temporary food labeling flexibilities that were issued under the Trump administration. Specifically, we saw some guidance issued, I believe it was in May of this last year, 2020, relating to minor formula changes that affected the ingredient list on packaged foods and allowances to not require manufacturers to update those ingredient lists, as well as allowances to let vending machine operators who would normally be required to disclose calorie information for vended foods to not have to do so temporarily during the pandemic. So other areas we'll continue to watch. Next slide. And so now kind of turning to some of the things that we're watching and focusing on at USDA. And to me, this is really an exciting space for us at PHLC to be focusing on and thinking about, just given its, the potential impacts that food programs at USDA, specifically at the Food and Nutrition Service, really have on all of America, including American kids. And this is just really, really an exciting space to be focusing on. So one thing that we're looking at are the kind of focusing on some of the efforts that the Trump administration had made to suspend, to roll back nutrition standards. And we're hoping to see that the Biden administration will suspend those efforts. Specifically, just to kind of get into a little bit of the nitty gritty, the Trump administration had issued a 2018 rule change to roll back nutrition standards, specifically related to things like whole grains, sodium in milk. And then it ended up proposing another rule in November of 2020, kind of at the tail end of the Trump administration, to try to reinstate these 2018 rule requirements after a federal court had vacated and actually remanded the 2018 rule due to procedural violations. And then additionally, in the interim, the Trump administration had proposed further rollbacks on meal standards in a rule that it published in January of 2020. And we at the Public Health Law Center, again, had specifically commented on that January 2020 rule, to point out, among other things, the really especially detrimental anticipated impacts that it would have for millions of children at risk for food insecurity, and pointed out that these changes would harm especially children of color, American, Indian, and Alaska Native youth in particular. Luckily, as I say, neither of the 2020 rules were finalized under the Trump administration, and it's our expectation that the Biden administration won't finalize them. But we have noticed, again, advocates in the space sort of calling for the USDA to use this as an opportunity, use the time as an opportunity to think about how the school standards could be better aligned with the current dietary guidelines for Americans, including, for example, to better align the meal standards with recommendations around sodium, as well as around added sugar. And then another area that we at Public Health Law Center see as a need is to do a better job than was done under the Trump administration in making any updates to these meal standards, to do better outreach with BIPOC organizations as they're thinking through what those changes might be. Also, another area for opportunity, again, seeing advocates talking about how to better improve the summer meal nutrition standards. There again, there's an opportunity to align them with the current DGAs. And then just, again, to kind of give you an idea of other things that we're following in the space, there had been a flurry of waivers around some of the meal programs right at the beginning of COVID, and many of those waivers, which allow for various flexibilities, have been extended multiple times actually throughout the pandemic. And there are currently several waivers, including 3 key ones that I have here up on the screen, that are currently set to expire in June. However, we are seeing advocates calling for these and other waivers to be extended through at least the rest of the summer to get kids, all the way up to the school year at least. So something we will continue to watch and sort of be aware of as things continue to progress with the pandemic. So that's just a sample highlights of some of the things we're looking at and some of the ways that we've been able to contribute in the space. As I say, I'm really excited about this area. And with that, I will hand it off to my colleague, Desmond Jenson, to move into sort of the Q&A component of today's webinar. Thanks, Desmond.
Yeah, thank you, Amanda, Kyra, and Rebecca. So we are getting a trickle of questions coming in. Feel free to put them into the Q&A box as you're thinking about them. I see a lot of familiar names in the attendee list, so feel free to try to stump our experts. I'm gonna give a sort of 2-part, totally unrelated question to you, Kyra, because I think one question is fairly discrete and short, and the other one we maybe want to spend a minute on. Take them in whatever order you want. The first question is, what does the changing administration mean for FDA action on menthol in cigarettes? Something we kind of left out of the webinar because it's not necessarily something the FDA is talking about, but I think we have a little bit to say about that. And then the other one is a clarifying question about PMTA applications. All the food people just went snooze. You said there were 58,000 applications or products that were accepted, which is a term of art in our world. And the question is about the fact that CTP said there were something like 4.8 million products. So if you can clarify that and then say what we need to say about menthol.
Sure. Yeah. So the numbers are a little confusing. So the FDA has received applications for 4.8 million products. That's correct. The 58,000 accepted applications is basically the first stage of the processing timeline. So they've really moved on, that very small percentage of the applications to begin reviewing it. I guess we don't have the slides up anymore, but I did have a little graphic that had all the little stages, but acceptance is the first stage. So it's slow. It's very slow, but you're right that the 4.8 million products is the number of products for which it has received applications. So hopefully that is somewhat helpful in clarifying that. So yeah, menthol. Oh yeah, thank you, Stephanie. There you go. Yeah, so acceptance is phase 1. Yeah, I guess it depends on kind of how we're framing what we want to talk about, because if we're talking about things that the FDA should be prioritizing in our perspective, it should absolutely be menthol. If we're talking about things that FDA is doing, it's not menthol right now. So as you may be aware, the African American Tobacco Control Leadership Council, along with other plaintiffs, sued FDA on June 17th of last year, basically asking the court to require FDA to issue regulations prohibiting menthol in cigarettes. And also at issue was the failure to respond to the citizen petition that we, along with other public health groups and AATCLC, submitted in 2013, requesting the same thing. So many years of inaction led to that lawsuit. And most relevant probably is the fact that on April 29th of this year, we're supposed to be getting a response from FDA, and anything other than, yes, we're going to be moving forward with a rule that prohibits menthol in cigarettes is going to be met with a lot of, with more litigation from public health groups, because that needs, the only answer is really that FDA is going to prohibit it. So that could be its own webinar. That was a long answer, and I'll stop now.
No, that's fine. And I would say look for resources for us on both of those topics in the near future. We're following what the FDA is doing with marketing applications, and obviously menthol has been a priority of ours for federal work for a very long time, since the very beginning. So I think we've got time for one more question, which I'm going to put to you, Amanda. And I guess Rebecca, feel free to weigh in as well. But I think Rebecca or Amanda is the one that mentioned, so there are other organizations that are also following federal food regulation, obviously, lots, and organizations we work with closely as it relates to nutrition and food, which is the areas that we are concerned about. So what do we see as the center's unique position in the food regulatory space, which is an area we're just sort of moving into?
Yeah, thanks, Desmond. This is a really great question. I think there are the couple things I'd like to say. One, there are already some really great people working in this space. And so I see us as really being able to complement the work that's already being done by some great organizations, CSPI, FRAC, among others. But to bring, as I'd mentioned earlier, kind of our unique expertise as attorneys to the space. So not just looking at kind of the science and some of the equity concerns, which of course we will be, continuing to watch and monitor and leaning into experts, especially in the science space, as we continue to work here, but really to bring that legal lens to understand where there are opportunities to point out where the agencies could be doing better in terms of due diligence and due process, and making sure that they're following legal requirements. And that was, I think, a huge part of, for example, our petition that we did around school meal changes that were for the rule that was proposed in early 2020. But another thing is, I think we at Public Health Law Center really kind of approach our work in partnership with other organizations. And so we really don't have an agenda other than public health itself, equity, and really just wanting to be, like I say, in partnership with other organizations. So it's really my hope that, as we do this work, we can be a resource to provide, what we call this technical assistance to support advocates and other organizations in the space that are interested in affecting change. And so what we will be doing, one of the things we're going to be doing, I hope, as we hopefully get more funding for the project, is to create really like a comprehensive one-stop shop where people can kind of come and see what the current opportunities are to be able to participate in the space, you know, when there are comment periods that are closing, that sort of thing. And then also, you know, to be able to provide that kind of that resource to be able to help people file their own citizen petitions, or maybe us to provide some of that kind of background research or writing to help them get things like that to the finish line, to comment on federal rulemaking in a way that is hopefully most impactful. So those are just a few of the opportunities that I'm seeing. Thanks for the question, Desmond.
Yeah, no, absolutely. I mean, just to echo all that, hopefully this webinar gives people an idea of like just how complicated federal regulation can be. And I think the goal of all of our regulatory programs are to make it as simple as possible for people out in the field who are busy and don't have time to read the Federal Register and look at the Unified Regulatory Agenda and do all the stuff that we can do quickly and get the information out to the people who need it as easily as possible. And the awesome thing about the federal regulatory process is it's so participatory. So we can reach out to you, the experts, and you can put your information directly to the agencies to make sure that we are getting the best public health outcomes. So with that, I think we will end. Thank you again to everyone who attended, and thank you to our wonderful presenters for being the experts today. Have a good day.